We're talking today about scenarios that were presented by the state of Missouri Department of Revenue, and they were presented to the Federal Motor Carrier Safety Administration to determine whether they were in violation of the Motor Carrier Safety Improvement Act that went into effect on September 30th, 2005. And these responses were received in late March 2006. One of the scenarios presented was basically a question to determine whether the masking provisions under 49 CFR section 384.226, which is the federal prohibition against masking convictions, whether the provision of that statute came into effect or was triggered by this scenario. The scenario was a commercial driver's license holder was issued a traffic citation for excessive speed. Okay, excessive speed in his or her private vehicle. And we know that according to the CDL rules, they look at whether it was a private vehicle or a commercial motor vehicle, and sometimes it matters, sometimes it doesn't. But when you're talking about the resolution of cases, whether someone has a CDL license is always the most important item. When you're talking about some of the punishments and some of the disqualifications, it's important to look at whether they were in their commercial motor vehicle at the time of the offense. So they were charged in their personal vehicle. They have a CDL. They're traveling 75 miles per hour in a 60 mile per hour zone. After the original charge is filed with the court, which means that the officer on the side of the road issued the citation, went to the clerk, we assume swore to the ticket, and it was put on the court docket. After it was filed with the court, the prosecutor amends the charge, the original charge, to speeding 65 miles per hour in a 60 zone. Very good prosecutor, very generous prosecutor. I'm sure there were some extenuating circumstances that would allow that. The final conviction was for speeding 65 miles per hour in a 60 mile per hour zone. There are a lot of prosecutors throughout the country, Alabama included, some judges, that would indicate that this is a violation of the masking provision of 49 CFR section 384.226. Let's see whether it is. Let's go to the folks that put this in place. Let's ask them. That's what Missouri wanted to know. They said, let's ask the folks that put it into place. Here's what they said. Maybe you'll be surprised. This practice is not in violation of 49 CFR 384.226 because the violation was reduced before a judgment of guilt was pronounced. In order to have masking of, and there's a statute that prohibits the masking of a conviction, you have to have a conviction first. In this situation, there was no conviction. This was done prior to the charge being amended. It says further, before we can apply the conditions in 49 CFR 384.226 to determine whether masking has taken place, there has to be a judgment of guilt, i.e. a conviction for a violation. There has to be a conviction first. The masking provision in 49 CFR section 384.226 does not prevent plea bargaining from taking place. We hear it all the time. I can't do anything because they have a CDL. I can't amend the charge. I can't amend the speed. I can't dismiss it. I can't do anything. Can't let them go to driving school. There's nothing I can do. There's nothing that can be done. My hands are tied. There's nothing I can do. I've been told by this person, that person, whatever it might be. When you look at this and you read this, you realize that that's not necessarily the case. Because we go back to Missouri requesting information about the Motor Carrier Safety Improvement Act from the folks that passed and pushed for this federal reg to be passed. So when you go back and ask them and they say, none of these things that you're doing are in violation of the Section 384.226, there's got to be some misinformation that's passed around. And our goal is to educate the general public, is to educate judges and prosecutors so that there is not, if the law provided for no plea bargaining, no reduction in speeds, no reduction in charges, if the law provided for that, then we would have to operate within that. The law does not say that. That's not what was intended. And therefore, it's our goal to educate everyone so that people realize that amending charges, amending speeds, and such is not in violation of the Motor Carrier Safety Improvement Act per the Federal Motor Carrier Safety Administration, based on the information that has been published. It's just not a violation. My name's Joseph Krebs. I'm a traffic violation defense attorney in the state of Alabama. We handle thousands of traffic tickets in the state of Alabama. If you've been charged and you have a CDL, you drive a commercial motor vehicle, we want to talk to you. All you have to do is call our office. You can reach us at 866-348-2889 to begin the conversation with us about your case. Or you can visit our website, trafficticketattorneyinalabama.com. Give us a call. We don't charge to talk to you about your case initially. All you have to do is call us, 866-348-2889. Thank you very much.